Today, in BNS, we will do multiple choice questions, which are very important and which have come in the previous year's examinations. In BNS, general principles of criminal law, as well as the first chapter, the multiple choice questions which come in the examination, we will deal with them. In chapter 1, there is a preliminary chapter. In that, section 1 deals with extraterritorial jurisdiction as well as intraterritorial jurisdiction. Section 2 deals with definitions. Section 3 deals with general explanations. Earlier, in IPC, chapter 1 deals with preliminary and the chapter 2 deals with general explanations. Now, both have been clubbed together. They have been put in the chapter 1. We will deal with the most important multiple choice questions. Those may likely to come in the coming examinations. While dealing with these questions, as and when the concepts will come, I will try to make it very clear and explain to you all about the concepts. The first question is the right to prosecution under Indian Penal Code. You may read it in the place of Indian Penal Code, BNS. The right to prosecution under the Indian Penal Code is affected by the provisions of other statutes, is not affected by the provisions of the other statutes, is not appealable, it is not applicable under the provisions of the Companies Act and is not applicable in the areas of Mikir Hills. The answer is B. Actually, the provisions of the Indian Penal Code as well as BNS, they will not be affected by the provisions of other statutes. The provisions in the BNS itself will cover the offences those have been mentioned there itself. If there are any other offences which have not been covered by BNS, there are separate statutes for them. Under those separate statutes, they will be dealt with. For example, NDPS Act is there, Narcotic Drugs and Psychotropic Substances Act. If any offense will be committed under that particular act, the case will be tried only under that particular act. So the answer for this question is the right to prosecution under the Indian Penal Code is not affected by the provisions of the other statutes. The second question is all are true except the one concerning the duty of the court in regard to the interpretation of the words of ambiguous import in a penal statute. It is a very important question. It is also for the practical purpose important one. Only one statement under these 4 statements is a false one, and the remaining 3 statements are true. You read this question very carefully. All are true except one. What is that except one? That concerning the duty of the court in regard to the interpretation of the words of ambiguous import in penal statute. It means in a penal statute, just like BNS, if there is any word there which is very ambiguous means unclear. Its meaning is not very much clear. Several interpretations may be given to that particular word. If such situation arises, what will happen? The court must ascertain if the offense charged is within the meaning of the words of the statute. Yes, it is true. If the only reasonable way of construing a penal statute without stretching its legal language is one which goes against the accused, then it must be fully upheld in its entirety. It is totally wrong. Which goes against the accused is the wrong statement. Which goes in favor of the accused. Whenever there is a word which is ambiguous, then the court must interpret that particular word in favor of the accused, not against the accused. That's why the answer for this question is B. Question number 3. Mens rea involves crimes of basic intent, right? Crimes of speculative intent, no. Crimes of specific intent, yes, it is true. Actually, speculative intent means that we are speculating that he has got intent. That is not permissible in criminal law. Only crimes of basic intent, those have to be taken into consideration, and specific intent also to be attributed to the accused. Then only mens rea can be interpreted. Correct. That's why answer for this question is mens rea involves crimes of basic intent and crimes of specific intent. All except one is false statement about legal mens rea. Again, while you are reading this type of questions, you must read it very carefully. All except one is false statement about legal mens rea. That means one is a false statement, the remaining three are the true statements about legal mens rea. It refers to mental element necessary for the particular crime. It is a right statement, correct statement. The mental element may be either intention to do the immediate act or bring about the consequences. Yes, it is true. It is very important. The mental element is not only at the time of the preliminary stage of actus reus, it also relates to consequences. That's why whenever you have got a guilty mind, that mens rea, at that time, at that particular point of time, you have been thinking not only about the act but also consequences. That is the meaning of this statement B. C. Intention or recklessness as to the elements constituting the actus reus. C. It is also correct. And the fourth one is intention can always be satisfactorily defined. No, intention cannot be defined. It is a mental faculty. It can be derived by the subjective considerations by seeing the circumstances around the crime. That's why answer is D. Now we will again go back to statement C. Intention or recklessness. What is this recklessness? Recklessness is also a shade of intention. Let us see here notes. Recklessness means there is no desire of evil consequences, but there is a foresight of evil consequences. Mens rea constitutes not only desire of evil consequences, but also foresight of such consequences. Mens rea consists of two parts. First part is desire of having evil consequences. We desire this thing should happen at the end of the actus reus. And also, we have to foresee such consequences will happen once actus reus will be successfully completed. Here, recklessness means there is no desire of evil consequences. While you are doing a recklessness act, then you have no desire of evil consequences. But you can guess that after doing that particular act, evil consequence may happen. For example, reckless driving. At the time of reckless driving, you don't have any desire to kill anyone on the road. But what happens when you drive recklessly? Then The accident may happen, the people may die. But you can have a guess. If you drive recklessly, rashnessly, then there will be a likelihood of casualty on the road. That is the thing. Recklessness means there is no desire of evil consequences, but you can guess that will happen after an act of service is completed. We have to understand the difference between recklessness and negligence also. Negligence will come later on, we will see to that thing also. Okay. Next, to which of the following the law of presumption applies? Presumption means guesswork. Volenti non fit injuria. Yes, here presumption applies. Menseria. Here menseria presumption will not be applied. De minimis non curat lex. What is the meaning of this particular word? First, we will see about this thing. Volenti non fit injuria. This thing will come in chapter 3 of BNS. Again, this particular phrase also we see in law of torts. Similarly, de minimis non curat lex, this also comes in chapter 3 of BNS, and this is also happen in law of torts. Volenti non fit injuria means to a willing person, no injury is done. It is a legal defense that prevents someone from recovering damages if they knowingly and voluntarily risk injury. BNS section 25 deals with this thing. Section 25 of BNS says, nothing which is not intended to cause death or grievous hurt and which is not known by the doer to be likely to cause death or grievous hurt is an offense by reason of any harm which it may cause or be intended by the doer to cause to any person above 18 years of age who has given consent, whether express or implied, to suffer that harm, or by reason of any harm which it may be known by the doer to be likely to cause to any person who has consented to take the risk of that harm. The definition is very lengthy one, but the explanation is very simple one. If any person is ready to take a risk and after taking that risk, he faces death or grievous hurt, it cannot be an offense. The person who is doing that harm, the person who is killing that person, who is the reason for the cause of the death of that person, or the person who is the cause of that grievous injury, cannot be held responsible. He is not accused. He is not a guilty person. That is what section 25 is saying. Example, if two persons are ready to do boxing, during that boxing, one person meets accident, he receives injury. Then that person cannot say the person who has caused the inflict of injury is a guilty person because he is willingly has given that person. He is willingly taken that risk. That's why the person who causes that death or grievous cannot be held guilty. Voluntarily, non-fit injury caused due to voluntary action that injury has been caused. That's why it is not an offense. But here there are two conditions. One is the person who is participating that risky act. He must be above 18 years of age. If he is below 18 years of age, he will be called a child. For the child, this section will not be applicable. And the second thing is, he has willfully has given consent to take the risk of that harm. He knows that if he participates in such a particular game, he may likely to get the accident, likely to get the harm. That is the thing under section 25. Here illustration also is given in the act itself. A and Z agrees to fence with each other for amusement. This agreement implies the consent of each to suffer any harm which in the course of such fencing may be caused without foul play. And if A, while playing fairly, hurts Z, A commits no offense. This is just like boxing. Here fencing thing has been told. Next we have seen this thing. De minimis non curate lex. It is means act causing slight harm. It comes under section 33 of BNS. Nothing is an offense by reason that it causes or that it is intended to cause or that it is known to be likely to cause any harm if that harm is so slight that no person of ordinary sense and temper would complain of such harm. You see that harm is very slight one, then it is not an offense. That is the meaning of this thing. Slight harm. Minimus means slight. Not curate. Lex matlab law. Lex means law. Slight harm is not an offense. Section 33 of BNS says this thing. For example, if a person slaps another person, it is a slight harm. It cannot attract offense and it cannot attract any penal provision. Next, what is the position of the mens rea in its purely technical sense for the offences under the Indian Penal Code? In the place of Indian Penal Code, you may read BNS also. It holds the same position as it does under the English criminal law. No, English criminal law is very specific. It has no application. Yes, it is true. In the case of BNS offences, in several offences, mens rea is not required. For example, socio-economic offences, mens rea doesn't have any role to play. It has indirect application. Yes, it is also correct because in most of the provisions of BNS, the words just like, intended, or knowingly, or dishonestly, or fraudulently, these words have been used. These all show the guilty mind of a accused. In that way, it has got indirect application. Nowhere in any provision of BNS, mens rea word has not been used. That means mens rea has been indirectly used in most of the provisions of BNS. Next, which of the following is a type of legal fault that necessarily does not involve a mental state? That means mens rea is not required. Again, I am telling, in each and every criminal act, there will be a guilty mind. But when we say that it does not involve a mental state, that means prosecution does not have any responsibility to prove that mens rea. Here, which of the following is a type of legal fault that necessarily does not involve a mental state? Negligence, yes, we have seen it earlier. Intention, both A and B, none of them. The answer is A. In the case of negligence, mens rea is not required. In the case of recklessness, earlier we have seen it. In the case of recklessness, yes, intention is required. Mens rea is required. Now, what is negligence? What is the difference between negligence and recklessness? These two things we must be very clear. Negligence means consequences neither foreseen nor desired, but remaining careless about one's act. It is very clear. The person who is doing a negligent act, he doesn't have any desire to do any evil consequences. Similarly, he has not predicted, he has not foreseen, he has not anticipated any evil consequence. Here, desire as well as forecast or foreseen or prediction both are absent in the case of negligence. But in the case of recklessness, there is no desire of evil consequence, but there is foresight of them. That means you have got the anticipation, you have got the prediction that evil consequence may happen. That means out of two things, one thing will happen in recklessness. That foreseeing of the evil consequence is there in recklessness, but in the case of negligence, foreseeing of the evil consequences as well as desire, both are absent. Now, next question. In which of the following conditions a corporation can be prosecuted? Very, very important question. Prosecution has been defined in section 2, subsection 26 under person. Sections 2, subsection 26 person means it includes any company or association or body of persons, whether incorporated or not. Whenever in any definition the word includes comes, you have to understand it is inclusive definition. Inclusive definition means in the definition certain things may be said very definitely. Beyond that also, beyond the four walls of this definition, so many things may be lying outside of these four walls. Those also can come within the purview of this definition. That is called inclusive definition. Opposite to this is exhaustive definition. If the definition is exhaustive, we have to see it, you have to interpret it literally. You cannot bring anything outside that definition within the purview of that particular definition. Here, person includes means company or association or body of persons, not only this. Anything beyond this thing also may come person. For example, a person is a man, a woman, a child, all these things. But these words have not come in this definition. That means it is an inclusive definition. But here what we have to see for the examination of point of view, that any company or association or body of persons, whether incorporated or not, these will be called person for the purpose of BNS. Earlier, corporations, very, very early stages of criminal law, corporation being an inanimate body, it has been presumed that corporations cannot commit any crime. That's why penal laws will not be applicable in the case of corporations. That concept has been changed with the change of timings. Corporations have started to cheat people. Offenses relating to properties, corporations do. Then the the view has been changed in such a way, yes, corporations can commit offenses, but the penalty will be, it cannot be any, if a corporation can be found guilty of any offense, it cannot be imprisoned, it cannot be sentenced to jail, but a fine can be imposed on it. That was the middle thought. In the middle time, it was thought that a corporation, if commits any crime, instead of a sentence, a fine can be imposed on it. Again, this concept has been changed. If any corporation commits any crime, then the mind behind that is the person who is controlling that corporation, that body of association, or that company, managing director, board of directors, like that, or some other very important person. His mind is flowing, his guilty mind is flowing into that actus reus. That's why for the criminal act committed by that company, if it attracts any sentence to jail, that person who is heading that body can be sentenced. Who is the cause of that particular crime can be sent to jail. That is the latest thought so far as corporation is concerned. Now we will see this question. In which of the following conditions a corporation can be prosecuted? If it is a person under section 11 of the Penal Code, section 226 of BNS, actually, in this question, what he is asking is, what is the section which is defining person? In IPC, person has been defined under section 11. Here in BNS, it has been defined under section 226. That's why correct answer is B. Section 12 is not talking about a person, section 10 is not talking about person, as well as section 14 is not talking about person. But you understand the interpretation which I have explained to you so far as person is concerned. Corporate bodies can be called persons and sentence can be imposed on it as well as fine can be imposed on it. That thing you remember. Which of the following sections of the IPC relate to extraterritorial operations of the code? What is this extraterritorial operation? What is this intra-territorial operation? We have to understand it very clearly. Let us go to the act and we'll see it. Okay. You see, this is section 1. Third, section 3, section 1, subsection 3. Every person shall be liable to punishment under this Sahita and not otherwise for every act or commission contrary to the provisions thereof, of which he shall be guilty within India. You remember, section 1, subsection 3 is intra-territorial jurisdiction. Intra-territorial jurisdiction means within the territory of, within territorial boundaries of India. That's why it is called intra-territorial jurisdiction. Any offense will be committed within India. Any offense will be committed within territory of India, then if the person who commits that offense, whether he is Indian or foreigner, then he will be punishable. Now we will see this thing. First of all, we remember this is section subsection 3 is called Intra-territorial jurisdiction. Here the question is, what is extraterritorial operation? We will come to that later on. Every person, while studying 3, 4 and 5 subsections, we have to remember two things. Whenever we see person, person means Indian citizen as well as non-Indian citizen. That means foreigner. If any Indian, if any Indian citizen or any foreigner commits an offense within the territorial boundaries of India, he will be punished. Next, section 5 we will see. The provisions of this Sanhita shall also apply to any offense committed by any citizen of India in any place without and beyond India. It is called extraterritorial jurisdiction. You see, if any Indian citizen, if he commits any offense that has been described under BNS in any foreign country beyond the boundaries of India, then he can be punished under BNS after bringing him into India. That's why if any citizen of India in any place without and beyond India means any citizen of India in foreign country commits any offense, that offense must be described in BNS. Then only this 5A will be applicable. If he commits any offense that has been described in BNS, then he can be brought back to India, can be tried for that offense. If in the case of any citizen of India, any person, if you write, it is a wrong thing. That means if any foreigner in any place without and beyond India, outside India, if any foreigner commits an offense, then he cannot be liable for the offense. It is applicable only for Indian citizen. Extraterritorial jurisdiction. Okay, extraterritorial jurisdiction is applicable to any citizen of India in any foreign country. Now we will see very interesting thing. B. Any person on any ship or aircraft registered in India, wherever it may be. You see, if any ship or aircraft is registered in India, if ship has been registered in India, it is sailing in African seas, high seas. If any American commits any offense against any German person, then also he is committing that offense on Indian ship, on a ship which is registered in India. That means he has committed an offense within the territorial boundaries of India. That's why that person can be liable for the offense. You have understood? If any ship or aircraft registered in India, any person, if Indian citizen commits any offense on ship or aircraft, he is naturally liable, because clause here comes that the particular thing. Any citizen of India in any place without and beyond India, he will be punishable. Similarly, any foreigner, if he is not a citizen of India, if he commits an offense on any ship or aircraft registered in India, wherever it may be, wherever it may be means in high seas, then he will be punished. And also, please remember, when we are talking about ship or aircraft, it is called admiralty jurisdiction. Admiralty jurisdiction, this word you have to remember, such question may come in the MCQs. This section 5B is applicable to Indian citizen as well as non-Indian citizen. And before going to clause C, we will see one more thing. I have told you every person shall be liable to punishment under this Sanhita, not otherwise for every act or commission contrary to the provisions thereof, he shall be guilty within India. Within Indian boundaries. If has been committed within the boundaries of India, India means from Kashmir to Kanyakumari. It is not like that. We have got a sea on three sides of our country, east, west, as well as south. 12 nautical miles from the seashore. That is also treated India. It is applicable as per international law. Any country's boundaries extend in the sea up to 12 nautical miles. That means if any person, whether Indian citizen or a foreigner, commits any offense within 12 nautical miles in the sea, then we will treat that he has committed that offense within India, and that person will be liable for the prosecution. You have understood this thing? If he is an Indian citizen, then there won't be any problem. If he is a foreigner and if he commits an offense within 12 nautical miles of seashore, then we will bring him to India and punish him. This thing you remember this 12 nautical miles within the sea, that also comes within the territorial jurisdiction of India. Now, Section 3 is an intra-territorial jurisdiction. Section 5 is extraterritorial jurisdiction. Or which of the following? Now we are coming to this thing. Now we will see the illustration also, so that we will complete this thing. Who is a citizen of India commits a murder in any place without and beyond India. He can be tried and convicted of murder in any place in India in which he may be found. Okay. If any citizen, that means if any Indian student commits any offense in United States university campus, if that the act committed by him is an offense, if he murders someone, that is an offense. He can be brought back to India and can be tried. He can be tried and convicted of murder in any place in India which he may be found. Wherever he would be found, because in the criminal law, generally trial will take place wherever the actual crime happened. But actually the crime happened in United States of America, some so and so university's campus. We cannot try him there. That's why if he will be found here in Arunachal Pradesh, he will bring there in Arunachal Pradesh and the trial will be done in Arunachal Pradesh. Similarly, if he will be found in Bombay, the trial will take place at Bombay. He can be tried and convicted of murder in any place in India in which he may be found. This subsection 6 also very important. That's why I will cover it here itself. Nothing in this Samhita shall affect the provisions of any act for punishing mutiny and desertion of officers, soldiers, sailors, or airmen in the services of the Government of India or the provisions of any special law or local law. This mutiny, desertion, are defense offenses. The officers in the defense will commit such kind of offenses. For that, specific acts are there. Under those acts also, only these people will be tried and punished. BNS will not be applicable in the case of mutiny and desertion of officers. Court martial will take place and after that punishment will be given. Court-martial system is there. That is a separate act. Next, we will come to this thing. Which of the following sections of the IPC list extraterritorial operations? Section 1.5 of BNS. We have just covered it. To which of the following section does this section 4 and section 1.5 of the IPC applies? Just now we explained any citizen of India in any place without and beyond India, extraterritorial thing. And any person on a ship or aircraft registered in India, wherever it may be. Oh, it is also extraterritorial jurisdiction. But any ship and aircraft that must be registered in India. If any person, any foreigner also, not only Indian citizen, any foreigner also commits an offense on ship or aircraft registered in India, he will be brought back to India and punished. Answer is C. Both A and B are correct. Appellant's son was married to the complainants and appellant was undisputedly a Mauritius citizen and her son and daughter-in-law were residing in Kuwait. A complaint petition was filed before the Chief Judicial Magistrate XYZ by complainant alleging therein mental torture and physical harassment by her husband. Section 498A case. Appellant, mother-in-law of the complainant, who was also made a party, filed an application for quashing of proceedings on the ground that cognizance taken by the magistrate was bad in law as she was a Mauritius citizen. Important. She was a Mauritius citizen and alleged offence was committed in Kuwait, where only cause of action had arisen. It is important thing. The appellant was a Mauritius citizen. She was seeking quashing petition under section 482 of CRPC. Then she is telling that I am a foreigner. I am not an Indian citizen. And offense was committed in Kuwait, not in Indian territorial borders, or not in any ship or any aircraft registered in India. That's why the entire proceedings has been illegally initiated and without jurisdiction, and actions taken by the court is liable to be nullified. This is the correct answer. Because the appellant is not a citizen of India and the offense has not been committed within the territories of India. That's why no case will arise within the territorial borders of India. Next. Which section of the IPC should be read as a provision to section 105 of the Evidence Act? Whenever you read such kind of things, you have to remember what is section 105. 105 is very, very important section. In several forms, this question will come. Not only here, in Evidence Act also, this question will come. Hear carefully. Section 105 of the Indian Evidence Act 1872 states that when a person is accused of an offense, the burden of proving the existence of circumstances that bring the case within any general or special exception or proviso lies on the accused, and the court presumes the absence of such circumstances. What is this general or special exception? In BNS, Chapter 3 deals with general and special exceptions. I will give 2 or 3 examples so that you can understand what is this general exception. If a child below 7 years of age commits an offense it is not offense. If the child below 7 years of age commits an offense under BNS, that is not an offense. That is the special general exception. Similarly, a person who has been forcefully intoxicated, liquor was forcefully given to him, then during that intoxication, if he commits an offense, that is not an offense. That is also exception. Similarly, if a mad person who has no control over his mind commits an offense under BNS, then also it is not an offense. This type of general exceptions have been given in chapter 3. There are several general exceptions. We will deal them with very thoroughly because that chapter 3 is very important for BNS. Okay. Whenever you are seeking any immunity under general exception, then the burden is on you to prove that you come within that purview of within that definition of that general exception. For example, you are saying that I am a mad person, that's why I shall not be liable for any criminal prosecution because I have got the general exception under chapter 3. Then the court will not believe you that you are a mad person unless you prove that you are a mad person. The burden has shifted from prosecution to accused to prove that he is a mad person. If he seeks immunity, that he is a child, that's why the offense he has committed is not an offense under chapter 3. Then also the burden is on the child himself that he is below 7 years of age. That means not the child, the guardian of that child has to prove to the court that he is below 7 years of age. That is the thing. Section 105 says that if you are seeking any immunity under general exception, then the court will not presume that you will come within that general exception. The burden is on you to prove that you come under that general exception. Now here we see the answer. Which section of the IPC should be read as provision to section 105 of Evidence Act? It is section 3(1) of BNS says this thing. We will see section 3(1) here. Throughout this Samhita, every definition of an offense, every penal provision, and every illustration of every such definition or penal provision shall be understood subject to the exceptions contained in the chapter entitled to General Exceptions. Though those exceptions are not repeated in such definitions, penal provision, or illustration. What section 3(1) is saying? What section 3(1) is saying is, there are several offenses defined in BNS. There itself, the punishment provision is also provided. What type of punishment that particular offense will attract? Whether it is imprisonment, or whether it is fine, or whether it is imprisonment and also fine, or whether it is imprisonment or fine, clearly it has been defined. But in chapter 3, general exceptions have been given. These general exceptions will be applicable to each and every offense which has been described in BNS. For example, culpable homicide not amounting to murder. And murder, there are two provisions. While we are studying culpable homicide not amounting to murder, their general exception has not been given. Even then, we have to read general exception in that particular provision. Because while we are reading culpable homicide not amounting to murder, there it has not been mentioned if a mad person, if a madman, if a mad person commits an offense. If a mad person commits culpable homicide not amounting to murder, it is not an offense. It has not been written there. It has not been written in section 299 as well as section 100 of BNS. But we have to read it. If a mad person commits culpable homicide not amounting to murder, this general exception has to be read by us in that particular provision. Similarly, in the case of a murder provision, if a mad person commits such an offense, then we have to read this general exception into that particular provision. Earlier question is that the burden of proving that a general exception is on the accused who has committed that offense. Okay, which of the following explains this one? Which of the following explains the sense of expression once explained? Next, section 3.2. Every expression which is explained in any part of the Samhita is used in every part of the Samhita in conformity with the explanation. Here, in IPC, a separate chapter has been given general explanations. But in BNS, general explanations has been clubbed with the preliminary chapter. That's why section 2 is a definition section. Similarly, section 3 is also a general explanation section. Joint liability sections. And here, every expression which is explained in any part of the Samhita is used in every part of the Samhita in conformity with the explanation. In any part of Samhita, some expression has been explained. For example, in any part of Samhita, the word provocation has been explained. But that has not been explained in definition class. In a definition, we don't see anything provocation. But that will be applicable in other part also. It is used in every part of the Samhita in conformity with the explanation. Similarly, joint liability explanation has been given in section 3 in various subsections. Though the general explanations have to be read in each and every provision of Samhita. This is the meaning of this thing. Every expression which is explained in any part of this Samhita means in any part of the Samhita expression has been explained that can be used in every part of this Samhita. Sense of expression once explained. Sense of expression once explained means in section 7 of IPC, this word has been used. Sense of expression once explained. In section 3.2, it has been used. That's why answer is C. Which of the following is a limitation with vicarious liability? What is vicarious liability? Vicarious liability means one person is held responsible for the wrong committed by the other. With a common intention, three persons go, and one out of those three persons killed that person. Then the remaining two persons also can be held responsible for the wrong committed by the one person. A, B, and C, they had developed a common intention to kill Z. Three of them went there. A and B were standing there, whereas C killed Z. Here, vicarious liability will be falling upon A and B. The wrong committed by C also will be attributed to A and B. One person is held responsible for the wrong committed by the other. Here what we are talking is the multiple choice questions. Corporation has been given. Whether corporation can be held liable, vicarious liability can be cast upon a corporation. That is the thing what we have to decide here in this question. Section 226, earlier it is section 11 of IPC, says a person includes any company or association or body of the persons whether incorporated or not. It is an inanimate thing. Okay. Certain crimes because of their nature cannot be committed by a corporation. True. Because murder, it cannot be attributed to a corporation. If managing director of a corporation commits murder, it is a murder, it is the offense committed by the managing director, not by the corporation. That means certain crimes because of their nature cannot be committed by a corporation. It is a true statement. But in the case of cheating, section 420 IPC, yes, if a corporation commits that thing or criminal misappropriation of property, yes, such kind of offences can be committed by the corporation. But some crimes cannot be committed by the corporation due to the nature of that crime. Next B, corporal punishment cannot be imposed on a corporation. Yes. Corporal punishment cannot be imposed on it. Cannot be convicted of manslaughter. Manslaughter means, actually this word is used in USA. We use it murder. A corporation cannot be convicted for murder. A and C are correct. Corporal punishment cannot be imposed on a corporation. It is a wrong thing. It can be imposed. Next, criminal liability of a corporation arises when an offense is committed in the course of corporation's business by the person in control of its affairs. Yes. An offense is committed in the course of corporation's business by a person in control whose thought and intent becomes thought and intent of the corporation. Yes. First part, A is telling about actus reus. An offense is committed in the course of corporation's business by the person in control of its affairs. Criminal liability arises. Similarly, here thought and intent. This is by a person in control of that corporation. It is mens rea. Here mens rea is the thought and intent of the person who is holding the control of that company, corporation. Here, actus reus is there. Criminal, that means criminal liability of a corporation can be attributed to an offense is committed in the course of corporation's business, not in a individual thing. If it arises in the course of corporation's business, then only, here also in the course of corporation's business, then only criminal liability of the corporation arises. Answer is C, both A and B. Which of the following is true of the word judge under section 19 of IPC, section 216 of BNS? We have to read all the definitions so that you can understand these things. It denotes a person officially designated as a judge. Denotes every person who is empowered by law to give a definite judgment in any legal proceeding, civil or criminal. C. Denotes of a body of persons which is empowered by the law to give judgment, and all of them. Answer is D. The reason is, you see, once you go through section 216 of BNS, if you go through the definitions, you can understand, because all these things have been brought from there itself. He did not add even a single word on his own. Judge means a person who is officially, I am reading the definition. Section 216. Judge means a person who is officially designated as a judge and includes a person. Again, it is inclusive judgment, inclusive definition. Who is empowered by law to give in any legal proceeding, civil or criminal, a definitive judgment, or a judgment, if not appealed against, would be definitive, or a judgment which is confirmed by some other authority would be definitive. B is telling this thing. Who is one of a body or persons which body of persons is empowered by law to give such a judgment? It is C. And a judge means a person who is officially designated as a judge. Denotes a person officially designated as a judge. From here, it has been taken down here. Okay. Now, illustration we see. A magistrate exercising jurisdiction in respect of a charge on which he has power to sentence to fine or imprisonment with or without appeal is a judge. This you remember, because this direct question will come from this thing. Illustration. Next comes, which of the following does not fall under the category of the word judge as coined in section 19? You see, here the same thing came. Magistrate, in the illustration itself it has been given. Member of a panchayat, yes, member of a panchayat, he participates in legal proceedings. That's why he is a judge. Collector, he also in quasi-judicial proceedings. In the Land Acquisition Act also, he gives a definite judgment. That's why he is also a judge. A businessman is not a judge. That's why answer is D. Which of the following amended added clause 11 and explanation 4 in section 21 of IPC? Actually, this question is irrelevant because it is IPC. Now, BNS has replaced IPC. That's why this question will not come. That's why I don't explain it. Okay. Next, in a certain case in Delhi, the accused proposed a marriage of his son with the gentleman of a daughter who was pregnant with someone else's child. A fact that has not been concealed. It is important. A fact that has not been concealed. That means there is no mens rea. However, he concealed the fact that his son is suffering from a mental disorder. The gentleman marries his daughter to his son, then the accused. But accused proposed marriage, he accused's son is a mental disorder person. But he concealed that particular fact. That means he has got mensaria. But in the case of daughter's father, he doesn't have any mensaria because he did not conceal the fact that his daughter is pregnant with someone else's child. He is he has come with clean hands, whereas the accused has not come with clean hands, and he concealed the fact that his son is not a healthy person. He is suffering from mental disorder. Now we will see. Accused means this person, bridegroom's father. A cannot be held guilty because even the gentleman's daughter is at fault. No, because gentleman has told about his daughter's aberration. In the case of B, B is a prima facie guilty of cheating due to the element of wrongful gain involved. Yes, he has concealed the fact. Mensria is there. What is wrongful gain? Wrongful gain means gain by unlawful means of property to which the person gaining is not legally entitled. You see, uh, wrongful gain definition is under section 236. You remember this thing because this definition is very important definition. But personal level, I have got a certain objection so far as this question is concerned. Answer, you see, is a prima facie guilty of cheating due to the element of wrongful gain involved. What is the wrongful gain the accused got it? Wrongful gain of getting daughter-in-law. Daughter-in-law is a human being. It is not a property. You cannot bring within the definition of property any human being, any man, woman, child. You cannot bring them in the definition of property. That's why this question, the MCQ option is itself somewhat obnoxious, I may say so. He is prima facie guilty of cheating. That is correct. Because he has got mensaria. Oral threat or inducement allegedly given by lawyers to a prover not to give any statement against accused amounts to commission of offense, does not amount to commission of offense, can attract discretion of the court to consider as offense. None of the above. Correct answer has been shown as B. Approver means the person who is also co-accused. He has got dirty hands in the offense, but state makes him as an approver, and he takes some information so far as crime is concerned, and main accused will be put uh, uh, under glare, under trial with the assistance of approver. That's why approver becomes prosecution's witness. Now, the answer is saying it does not amount to commission of offense. If accused's counsel threatens or induces means giving something in return. If he approaches the approver, the counsel for the accused approaches the approver and says, I will give you this and that thing. Don't say anything against the accused, whether it is an offense or not. The answer I have searched in from several sources. It says it does not amount to commission of offense. How and why? It is a very difficult thing to say. But the answer has come like this without giving any clarification. If you are threatening any witness, that is an offense. Even then, it has been told like this. Next question is, if the appellants are liable to be convicted only for their individual acts, then Section 34 IPC can be invoked. Section 34 IPC cannot be invoked. It is correct answer. Section 149 IPC can be invoked. Section 149 IPC cannot be invoked. Here, if any offense has been tried, and in that offense there are two or more than two accused, and after the trial is completed, if the judge convicts them, convicts each and every individual for their individual act, and the judge does not find any common intention among those persons, among those accused, then Section 34 he cannot invoke. Even though the trial can take place under Section 34, but once after the trial is over, the judge cannot find any common intention among the accused, sharing of thought to do that to commit such an offense, then Section 34 cannot be invoked. It is answer B. Common intention is absence. Under the general principles of criminal law, the jurisdiction to try for an offense depends upon place where crime committed within local area. This is the answer. General principle, where offense has been committed, there only the trial will take place. If a person will be found somewhere else, he will be brought back to the area where the offense has been committed. That's why the answer for this question is place where crime committed within the local area. That is the general principle. There are exceptions. For example, in the Gujarat riot cases in 2002, those have been tried in Bombay. But there was a transfer petition before the Honorable Supreme Court of India. Honorable Supreme Court transferred those cases from Gujarat jurisdiction to Maharashtra jurisdiction. But those are exceptions. You have to remember this general principle, place where crime committed within the local area. The term harbor defines under Indian Penal Code 1860 does not include. Now in the BNS section 213, it defines harbor. Let us first read this harbor definition, then we will try to answer that question. Harbor includes supplying a person with shelter, food, drink, money, clothes, arms, ammunition, or means of conveyance, or the assisting a person by any means, whether of the same kind as those enumerated in this clause or not, to evade apprehension. The important word here is evade apprehension. Evade apprehension means arrest. When arrest takes place? When offense has been committed, only after that arrest takes place. If a person has committed an offense, to avoid arrest, he goes to his known persons and asks them for shelter, रहने के लिए जगह, फूड, खाना, ड्रिंक, पीने की पानी वगैरह, शराब वगैरह, मनी, आने जाने के लिए कुछ खर्चा, जेब खर्चा वगैरह, क्लॉथ्स, कपड़े वगैरह, कुछ दिन छुप के रहने के लिए, आर्म्स, हथियार, एम्यूनिशन and all these things, guns, knives and all other things, and means of conveyance, भागने के लिए कोई गाड़ी वगैरह चाहिए, और सिर्फ इतना ही नहीं, जितनी चीजें यहाँ बताए गए हैं इनके अलावा और कोई चीज की जरूरत पड़ जाएगी. दैट्स व्हाई इट इज नॉट एग्जॉस्टिव वन. It is inclusive definition. By any means, more than these things, if any person has some other thing, that also comes within the harbor. Whether the same kind as those enumerated, इसका मतलब ऊपर से जो बताया गया है वही नहीं है और कोई चीज भी मांग ले वो सारे. But the condition is to evade apprehension. अरेस्ट से बचने के लिए ये चीजें मांग लिया गया तो वो हार्बर में आ जाता है. अरेस्ट से बचने के लिए नहीं होगा तो नहीं. क्राइम करने से पहले, if these things are asked before committing the crime, if all these things are asked, then those will not come in the definition of harbor. That difference you have to understand. All these things will come within the harbor, but only after committing the offense and avoiding the arrest. Or if he has been alleged to commit an offense, he did not commit any offense, but police is hunting him. He is avoiding the arrest because there is an allegation that he has committed that offense. If he seeks something from his known persons, then those persons give these things, it is harbor. Now we will come to the question. The term harbor defined under Indian Penal Code 1860 does not include supplying a person with shelter, shelter आ गया. Supplying a person means of conveyance, conveyance आ गया. Assisting a person to evade apprehension, very, very important thing. Prior to the commission of the offense, facilitating the commission thereof. It is not there. In the harbor, it is not there. That's why the answer is D. If a person is trying to commit an offense, for that he is taking all these things from any person. That is not coming within the definition of harbor. For example, I am going to purchase a gun from a local market. A businessman sold his gun to me. He may be committing some other offense. I have not committed offense. Just before committing the offense, for commission of the offense, वो अपराध करने से पहले ही मैंने वो चीज उनसे ले ली. गन. Then that will not come in the case of harbor. But it may attract some other offense. Next, read the following. These questions are quite often coming in these days. Indian courts have jurisdiction to try crime committed by an Indian in a foreign country. Yes, it is true. If Indian is committing any offense in India or abroad or in a foreign country, Indian courts have got jurisdiction. Let us see the second statement. Indian courts do not have jurisdiction to try crime committed by a foreigner in India. No. We cite the definition is telling any person who commits offense within territory of India, he is punishable. Indian courts do not have jurisdiction to try crime committed by no foreigner. If a foreigner commits any offense within India, not only within India, in a ship or an aeroplane registered in India, then also if a foreigner commits an offense, then he will be triable within the jurisdiction of India. Not only that, within 12 nautical miles from seashore, if any foreigner commits an offense, then it is punishable in Indian jurisdiction. I will give you an example. Two Italian naval persons came in a ship and its flag is hoisted. Italian flag has been hoisted. That means that ship belongs to Italy. Two Italian sailors came about 7 to 8 kilometers within the sea waters of uh, Kerala coast. There, two fishermen were traveling in a boat and were sailing in the boat. The sailors thought those were pirates and killed those two people. But the offense has been committed within 12 nautical miles of Indian seashore. Those two sailors who are the citizens of Italy, they have been brought to India and they have been tried here. This example you remember. Next question, which of the following is not sine qua non for making a person criminally liable? What is this sine qua non? Sine qua non means an essential condition, a thing that is absolutely necessary, which is not essential. Actus reus, it is essential. Mens rea, it is essential. Motive, it is not essential. All the above, no, motive is not essential. You remember this thing, motive is not essential. Motive is only a key to find out what is mens rea. It ignites mens rea. It fuels mens rea. Next, in which case the court made a clear distinction between common intention and similar intention. Very, very, very important question. Remember this thing. Birendra Kumar Ghosh versus King Emperor, that also belongs to common intention, landmark judgments. Mehboob Shah versus King Emperor, it is the correct answer. To remember this case is very important. This is 1945 case. This case is coming quite often in the examinations. But to remember this case, we have to go through the facts of this case. Actually, facts of the case are not important, but why we read facts of the case is so that we can remember this particular case, or otherwise only we read settled case of law. Sometimes we may miss because there are several cases, about 300 to 350 cases we have to read. And if we read only settled case of law, and we will not try to find out the facts of the case, then the cases may slip out of our mind. That's why to retain it in our mind, we read facts, and once we read these facts, this will become a key for us to find out the actually settled law in that particular case. That's why I wrote a very lengthy facts of this case. You see, Allah, the deceased, who was the resident of village Khandakir, it is in Punjab, on the date 24th of August 1943, along with Hamidullah and few others, went to Indus River bank by boat for collecting reeds. As they reached the river bank, Muhammad Hussain Shah, father of Wali Shah, was taking a bath on the river bank. He warned Allah and others against cutting reeds as the land belonged to Muhammad Hussain Shah. But they did not stop and collected 16 bundles of reeds and started returning. On the way back, they were stopped by Ghulam Shah, nephew of Hussain Shah. This Hussain Shah, his nephew is Ghulam Shah, who asked them to return the reeds because the property belongs to Hussain Shah. This Aladad and his friends are taking it wrongfully. That's why Ghulam Shah stopped them and asked them to return the reeds. But Aladad and his friends refused to return the reeds. On this, Ghulam Shah, the nephew of this Hussain Shah, hit Aladad with a stick, but the hit was missed. Allah Dad was hit by a stick by Ghulam Shah. Then Allah Dad hit Ghulam Shah with a bamboo. Bamboo means that is also stick. Ghulam Shah then started to shout for help. Actually, Ghulam Shah first attacked Allah Dad, but it was missed. And Allah Dad also used his bamboo and beat Ghulam Shah. And Ghulam Shah shouted for help. On hearing his shout, Mehboob Shah and Wali Shah, these are the accused in this case. Mehboob Shah and Wali Shah. I gave all this background for only to understand this thing. Who is this Mehboob Shah and Wali Shah? These Mehboob Shah and Wali Shah are also belonging to Hussain Shah. These are relatives of Hussain Shah. On hearing his shout, Mehboob Shah and Wali Shah rushed there with loaded guns. Allah Dad and his friends started running away. While running away, Wali Shah fired at Hamidullah and he died instantaneously. Wali Shah died. One murder had taken place. Mehboob Shah also fired at Allah Dad, because of which Allah Dad suffered severe injuries, but later on Allah Dad also died. That means two people died, Hamidullah and Allah Dad. Wali Shah absconded. Once he absconded, there was no trial. But Mehboob Shah was captured by the police. Once Mehboob Shah was captured and a trial had taken place, then along with the murder charge, Section 34 also has been invoked. Now Section 34 has been invoked. While the Privy Council has decided this case, it has become a landmark case on account of this Section 34. What are the essential elements of Section 34? We will come later on. First, what happened in this case, we will see it so that you can understand. The Privy Council acquitted the appellant called Mehboob Shah, acquitted the appellant, convicted under sections 302 and 34, 302 and 34. The Privy Council held that in the present case, there was no scope of pre-planning between the appellant and Wali Shah. Why I gave the facts of case in very detail? Because you see that there was no pre-planning. These two people came after hearing the shouts, and there itself, they did not have any common intention to kill those people. Since the facts of this case don't satisfy the elements of Section 34 of the IPC, this section won't be applied to this case. That means Section 34 won't be applied. The judgment passed by the Privy Council in Mehboob Shah versus Emperor case became a landmark judgment as it differentiated between common intention and same intention. Here they had got a same intention, but their intention is not common intention. Mehboob Shah and Wali Shah, they had got a same intention to kill those persons, but they had no common intention. The judgment even in today's era is relevant and also of great importance. Now we will see what is Section 34. Section 34's essential elements are criminal act. The act should be criminal in nature. That means the act what has been committed is an offense. Second, two or more persons. If there is a criminal intention, common intention is there. That common means there must be at least two persons. A single person does not have any common intention. For having a meeting of minds, there must be at least two minds. That's why minimum two persons are required. More than two, any number of persons can be allowed. 4, 5, 6, 10, like that. The criminal act should be done by two or more persons or several persons. Now, what is the third ingredient? Common intention. It means that there should be simultaneous consent of minds of persons participating in the criminal act. Simultaneous consensus of the minds. Pre-plan. There should be a pre-plan. A pre-plan may be hatched at the crime site itself. That is a different thing. But there must be a pre-plan. Meeting of minds and that consensus must be there. Consensus must be there. It is a very essential ingredient. And there is a difference between common intention and same intention or similar intention. For example, if A wants to kill Z, B also wants to kill Z. But A and B, they did not have consensus of minds. They did not hatch a plan. They did not have a common intention. Once A beat Z with a stick, with an intention to kill Z, then B also came to that particular spot. He also used his stick and beat Z. And due to these beatings, Z was killed. Then A also had intention to kill the Z. B had also got the intention to kill the Z. They have got the same intention, but they did not have common intention because they did not have a pre-plan to kill Z. Even though their intention was to kill Z, but independent individual intentions. Now I think that you have understood the difference between common intention and same intention. Now the answer for section 26 is Mehboob Shah versus King Emperor. Here common intention and similar intention, the distinction has been laid down by the Privy Council. This is also important. You remember this thing? This case has been decided in the Privy Council in 1945 by Privy Council. This question is coming. Who has decided this case? Privy Council, Supreme Court, and other things. As this case has been decided in 1945, time and again I am telling because at least 4 or 5 times in UGC examinations, the year in which the case has been decided has come. Next, to establish section 34 IPC, common intention be proved, but not overt act be proved. Common intention and overt act both be proved. Common intention need not be proved, but overt act be proved. All the above. Section 34 is talking only common intention, but is not talking about the overt act. That's why here you see the essential elements. Here there is no overt act. That's why the answer is common intention has to be proved to invoke section 34. This question is very important. Section 34 of IPC creates a substantive offense. It is a rule of evidence. Both A and B, neither A and B. The answer is it is a rule of evidence. Section 34 is a rule of evidence because Section 34 in BNS it has been described as Section 3, subsection 5. So you remember that thing also. Or nowadays, if the question comes, it comes like this: Section 3 within brackets 5, subsection 5 of BNS. It is only a rule of evidence. What is the difference between the substantive offense and is a rule of evidence? A substantive offense carries sentence or fine. It is an offense. If you commit that act which has been described in that offense, then it will carry if you will be put in jail, or the court may put fire against you. It is substantive offense. 1 year imprisonment, 2 years imprisonment, 3 years imprisonment, 5,000 rupees fine, 10,000 rupees fine, like that. But in the case of Section 34, it is a common intention. It doesn't give any punishment. It doesn't prescribe any punishment. It is only a rule of evidence. We have to prove that there is a common intention among them. Then each and everyone is liable for every act committed by them. That's why Section 34 is a rule of evidence. What is the difference between Section 34 and 149? Section 34 is common intention, CI, common intention. And Section 149 is common objective, that is called CO. We have to read the differences and commonality between Section 34 and Section 149. When we read after I complete chapter 5. And before completing chapter 5, I will come to this thing and common liabilities. There, I will explain in detail Section 34 and Section 149, or Section 3 subsection 5 and Section 190 of BNS. In the case of Section 149 IPC, that is common objective, that creates a substantive offense. Here, it does not create a substantive offense. It is a rule of evidence. One more difference is there between Section 34 and Section 149 that I explain here itself. In Section 34, 2 or more persons are required. But in the case of Section 149, 5 or more persons are required. That is very important difference you have to remember. X and Y go to murder Z. X stood on guard with a spear in hand, but did not hit Z at all. Y killed Z. Only Y is liable for murder of Z. X and Y both are liable for murder of Z. X is not liable as he did not perform any overt act. The answer is B. X and Y both are liable for murder of Z. Why? X and Y go to murder Z. There is a common intention. Section 34 is there. That's why if there is a common intention, each and every act done by Y is attributable to X also. That's why X and Y both are liable for murder of Z. Next,